Hello everyone and welcome to the 5th Melbourne Forum on Constitution Building in Asia and the Pacific. On behalf of International IDEA and the Constitution Transformation Network, I would like to welcome you all to this webinar series, where over 4 sessions we will be exploring issues of democratic representation during emergencies, issues that have been driven to the fore by the COVID-19 pandemic, but which have great significance for constitution building and constitutional practice. So my name is Ela Atienza. I'm a convener of the Constitution Transformation Network, and I'm very pleased to chair this first session from the University of Hong Kong. So the Melbourne Forum is a very special event for us at the Constitution Transformation Network and at International IDEA. In the past, we have met in Melbourne, the Philippines, Sri Lanka, and Myanmar, and we're pleased that despite the pandemic, we can continue this annual event online and include not just an extraordinary group of speakers from 16 countries in the region, but also many observers from all over the world. We'll do our best to capture some of the magic of the Melbourne Forum in this online format. So when I come to chair the panel a little later, I'll explain the logistics for moderating our discussions online. For now, however, I just want to draw your attention to the fact that this Zoom conference is being recorded and live streamed on YouTube, and for those on Twitter, we will be tweeting from hashtags Melbourne Forum 2020 and MF5. So before we do that, we will have a short introductory session and welcome. We will be led by Lina Rekila-Tamang, who is the Director of the Asia and Pacific Regional Program of International IDEA, and Cheryl Saunders, who is Laureate Emeritus Professor at Melbourne Law School and a convener of the Constitution Transformation Network. So Lina and Cheryl will formally welcome you. They will talk a little bit about what exactly the Melbourne Forum is, so you know what to expect over the next 4 sessions, and introduce the theme of this year's forum, which is representation in democracies during emergencies. So Lina, I'd like to invite you to speak, followed by Cheryl.
Thank you so much, Anna, and also on my behalf, warm welcome to our experts, to our alumni, and all of you who are joining us online, including representatives of International IDEA member states and members of our board of advisors. Excited to have so many of you online. I'm joining you at this forum from Canberra, Australia, where our regional office is located, and hence would like to acknowledge the traditional owners of the land we live and work, Ngunnawala people, and pay my respects to the elders past, present, and emerging. As Anna mentioned, the Melbourne Forum 2020 is investigating the issue of democratic representation from standpoint of emergencies. And emergencies come in a wide variety of forms, and the COVID-19 pandemic, which is the lens we are using, has given rise to both health and economic emergencies of major proportions. And the response by states, as we will learn from the presentations, has varied from impressive success to significant failure. And at the same time, most countries have in fact both positive and negative lessons to take on. Of course, recognizing that we are still very much in the middle of the crisis. I thought I should say a few words about why this forum and what do we hope to achieve. In brief, Melbourne Forum is an effort to bring people involved in and fascinated by constitutional issues in Asia and the Pacific region together, to learn from each other, others' experiences, to support each other through peer advice, and to create a community of practice and to create new knowledge and insights. Asia and the Pacific is a region rich with innovative constitutional approaches applied in contexts characterized by extraordinary diversity and complexity, and which should be, we think, should be shared with the rest of the world. Region has its challenges too, and this ongoing emergency has certainly proven stressful from the democracy point of view. International IDEA's COVID-19 global monitoring tool on democracy and human rights, which can be found from our website, points out to worrying global trends this pandemic has caused. In particular, when it comes to freedom of expression, media integrity, checks on government, and absence of corruption. These are the areas to watch out for. And these were the areas to watch out for already before the pandemic. Indeed, it seems that this pandemic is only exacerbating and accelerating ongoing global democratic trends, both positive and negative. And in terms of positives, we will learn some very interesting democratic innovations during this forum. I should mention in this context that in this work of depicting trends and sharing knowledge, IDEA works also in close collaboration with COVID-DEC of DEMDEC, Democratic Decay and Renewal Info Hub, hosted by Melbourne University and curated by Dr. Tom Daly, who is also joining us today. This is our 5th forum. As Anna mentioned, we started in 2016 in Melbourne, followed by forums in the Philippines, Sri Lanka, and Myanmar, and now this 5th one in Zoom. The previous forums always devoted a day to discuss the particular issues of the host country, anchoring our forums with the ongoing reforms and working with national partners. It is our shared desire, both international ideas and as well as of constitution transformation networks, that the insights that we are able to distill from the country case studies and discussed amongst the peers can be of practical use by actors involved in reform processes. Just to finish my opening remarks, I want to express my appreciation to our partner, Constitution Transformation Network, and all the people, all the amazing people, and in particular to Professor Cheryl Saunders, without whom there is no Melbourne Forum. It's really her indomitable spirit that keeps us going, and it's her network that enables us to gather this extraordinary level of people around the table every year. The simple fact that no one can say no when Cheryl invites is the very key ingredient for our success. I look very much forward to what our panelists have to say, comments and questions their presentations provoke. And do note that it's always been something said during the forums that has inspired the theme of the next one. So thank you so very much, and back to you, Anna.
Thank you so much, Lena. Cheryl, did you want to talk now?
Thank you. Thanks, everybody. And thank you, Lena, for that splendid introduction. I should begin by saying that I'm presently in Melbourne, and I acknowledge that I am on the land of the Wurundjeri people, and I pay my respects to their elders, past and present. And let me begin by also welcoming you to the 5th Melbourne Forum on behalf of my colleagues and myself at the Constitution Transformation Network. As Lena's just noted, the forum is jointly organised and hosted with International IDEA. And I should say at the outset how much we appreciate their partnership over the years in this and as in so many other things. A special welcome on our behalf and thanks to the 18 forum speakers, many of whom are online today, who've joined us this year to develop such a terrific program that will be run over the coming month. And welcome also to all of those of you who've registered for these webinars. And we'll talk a little bit more about that in a moment. The theme of this year's forum is representation in democracies during an emergencies, viewed through the lens of responses to COVID-19. And that theme brings together two of the most pressing questions for democracies that are being debated around the world in 2020, representation and emergencies. As always, the forum explores these questions through the experiences of Asia-Pacific countries as one of the most diverse regions in the world, offering constitutional insights that are not often enough reflected in global accounts. And I too am very much looking forward to the discussions. As my colleagues have noted, this 5th Melbourne Forum is the first one to be held online for reasons with which we'll all be familiar. But let me say just a little bit about the Melbourne Forum process. In the past, what we've done with the forum has been to bring together in one place up to 20 speakers from countries across the region for a vigorous exchange of ideas and experiences on a particular theme. It's proved to be a very successful format, and we've tried to replicate it as far as possible with this online forum. So as a result, we have 18 extremely interesting speakers from 18 jurisdictions across the region, ranging from Pakistan to Fiji in geographical terms. The forum theme has been divided into 4 sub-themes with speakers assigned to each. And each of the speakers has prepared answers to the questions sent to them, and they're now available on the Melbourne Forum website for those of you who haven't seen them already. But on the other hand, there are necessarily differences in this year's forum as well. One is that the sub-themes will be examined in 4 separate webinars on successive Thursdays in September. And we very much hope that you'll join us for all of them if you possibly can. And on the plus side, of course, the online format enables us to have a much wider audience of registrants from across the region and the world than has ever been possible face-to-face. So when it comes to discussion, we hope that all the forum speakers will engage as vigorously as ever, but registrants are also encouraged to submit questions, and Anna will talk to you a little bit about that process in a moment. And if we can't answer all the questions in this webinar, we'll certainly try to harvest them and hope to answer them in due course in other ways. So the sub-theme for today is literally emergency powers, in or outside constitutions, how they're triggered, how they work, and we have a fascinating series of papers to that end. The topic has particular application in dealing with the pandemic, but it's more widely relevant as well. Suddenly, emergency powers has become a very big question in constitutional law and constitutional practice. Later sub-themes for the forum will cover the role of representation during emergencies, multi-level government and representation, and other forms of checks and balances. So now let me hand you back to my colleague, Dr. Anna Jedjits. Anna is presently a global fellow, academic fellow at the Hong Kong University, and she's also a convener of Contransnet. So we hope you all enjoy today's webinar and those that will follow. Back to you, Anna.
Wonderful, thank you so much. So we'll just begin the first session. So this first session focuses on the theme of emergency powers. It will explore whether, why, and how constitutional or legislative emergency procedures have been used in response to the COVID-19 pandemic, both the health aspects of the pandemic, but also the economic fallout, and what impact this has had on representation, oversight, accountability, legality, etc. So we have 5 panelists to present at this session. They're from the Solomon Islands, Thailand, Timor Leste, the Philippines, and Japan. And I'd like to invite each of the panelists, the 5 panelists, to switch on your videos and join me as we hear from each of you. Again, though, please keep your microphones off to avoid the background noise. So I'll introduce each of the speakers in turn before they speak. But just to reiterate, as Cheryl explained, each speaker was given the same set of questions to respond to in response to their jurisdictions. And these questions are set out in the program, which is available on the Melbourne Forum website. But briefly, they include questions such as what mechanisms were used to handle the challenges of the pandemic and what was the effect on normal government, whether a constitutional or legislative emergency power was available, and if it was, whether it was used or not, how representatives of the people have been involved in approving and overseeing the use of emergency powers, and a practical question about how well these measures have worked so far. So our speakers face the rather difficult task of capturing the key insights from their countries in 5 minutes. But we hope that you've all had a chance to read their short written responses to the questions, and they're available on the Melbourne Forum website. We do have nearly an hour set aside for discussion after the presentation, so that will give us room for elaboration and discussion. So our first speaker is Georgina Kekea. She's a freelance journalist with over 20 years experience in the Solomon Islands, and she's also president of the Media Association of Solomon Islands. So Georgina, I'd like to invite you to give us your 5-minute presentation on the emergency powers in the Solomon Islands. Thank you.
Thank you so much, Anna. Hello, everyone. If you haven't heard about the Solomon Islands is a Melanesian bloc in the Pacific region. Currently, I think it has about 600,000 plus population. It's quite a small country. And luckily, we are still one of the countries that, that is free from COVID-19 as yet. And so currently our government is working very hard to keep COVID away. But from my discussion paper, which I presented earlier, it was a paper which I wrote with one of my colleagues, Dr. Anu Wright Dolayano. She's also here in the Solomon Islands, and we presented that paper earlier on in the year. But then, as we all know, COVID-19 has brought about new changes, especially with the state of emergencies coming up. And for us in the Solomon Islands, state of emergencies only take place when there's a war or when there's a disaster. So this is the first one of its kind, especially when it comes to health. So on 11th March, when the coronavirus was declared a global pandemic, the government of Solomon Islands decided it fit that we should declare a state of emergency. So on the 25th of March this year, it was declared a state of emergency, and then later extended by the government until July. And then from July, it was further declared by the Governor General that the state of emergency still exists in Solomon Islands until November. So you can see how much of impact it has in a small country as Solomon Islands. Like, we really do not really have the much human resources, and also when the state of emergency was declared earlier in the year, an oversight committee was established by the government. They consist mainly of the permanent secretaries in the government, and most of the oversight committee was there to oversee work, especially when it comes to responding to the coronavirus and the plans that are in place. So the oversight committee was set up in March. To date, they still oversee the operations here in Solomon Islands. And mainly, most of the resources that we have are very small when it comes to not only human resources, but also in terms of capacity in health. We've had some support coming in from donor agencies that has been helping Solomon Islands in terms of equipment and all that. But then on the other side, as coming from the media, there's this role that we have to play in reporting issues, especially during this time of state of emergency. There were not so much restrictions, but the access to the people that we need to have to speak were some of the issues that we were faced with, because they were also busy, like everyone's just caught up in doing the work in the oversight committee. Even though they do have conferences, not really conferences, but radio talkback shows and trying to make the public informed of what's been happening. The missing link is the communication between the media and the government. So the media is finding a hard time accessing these people, especially when it comes to issues of COVID, and also when it comes to making them accountable in terms of finances and all that. So those are some of the issues which the media here in Solomon Islands is faced with. As I've mentioned earlier, human resources is one setback, not only from the media industry, but also in the government sector, where the last report, which was given by the National Emergency Operations Center, cited that most of the workers are now facing fatigue. They've been so overworked with flights coming in, quarantine being made, made to look after those in quarantine and all that, that they are facing fatigue. They have to re-roster themselves. So to access those kind of resources which we need to disseminate information that is factual and also accurate is kind of some of the shortfalls which we are faced with. So basically, in a nutshell, that's how it's like for us in the Solomon Islands, such a small country. But when it comes to keeping our borders safe, there's so much the government is doing that they are sort of like overworking themselves in trying to keep COVID-19 out. Is that my 5 minutes done?
If you want a few more minutes, you can, but that's nearly 5 minutes.
Yeah, so that basically sums up how it's like for us in the Solomon Islands.
Fantastic. Fantastic. Thank you so much. Solomon Islands is interesting to us because there is this extensive state of emergency, but yet no COVID cases. So it's a very important kind of example to compare with others in the region. And I think some of the concerns that you raise about media access and government accountability will certainly be echoed by other speakers. So thank you very much. So our second speaker is Dr. Khemthong Tonsakulrungruang, and he's an academic at Chulalongkorn University, specialising in constitutional and administrative law. So Khem knows how all of this works. He's participated in Melbourne Forum before, and he will present on how Thailand has responded to the COVID-19 emergency. Khem.
Thank you very much, Anna, and greetings from Bangkok. So we are still Thailand in terms of health proved to be a huge success. We are able to contain COVID transmission, and we have been, I think, almost 60 or 90 days without any new transmission locally. So that's a success. The question is at what cost, and it's a very costly success indeed. So there's a few points that I would like to touch upon. The first is a clarification that the Thai constitution doesn't grant the government the emergency power. There's an emergency power granted to the junta and during the military government, but for the electoral government, normally we don't have that emergency power that you can do whatever. However, there's an emergency legislative powers that allow the government, the cabinet, to legislate law and ask for approval from the parliament later. And that's what happened in 2005, that the government promulgated the Emergency Act in 2005. And that is our main tool in to combat the COVID-19. So it's at the legislative level. However, so that has been that's 2005, and Emergency Act has been incorporated and normalized into our constitutional culture. It has been provoked many times by almost every government ever since. Though mostly it's invoked for controlling riots, controlling insurgencies in the south, and that's how it's normally used. This is the first time that we use it for public health reason. And because it's so ingrained in our culture, unfortunately, Thais has a tendency or inclination to accept the heavy hand measures, including the use of emergency act to control and to take away our rights. So, for example, when the government introduced the Emergency Act in 2005, the parliament vote accept, although there's many flaws, but because the government has the majority and they vote according to the party's stance, so everyone vote accept this Emergency Act. And the Emergency Act has a clause that prohibit judicial review from the administrative court, which is considered in the Thai context, the administrative court is quite progressive in terms of protecting rights and liberties of Thai. That doesn't mean that there's no oversight at all. There's a weak form of judicial review by the Court of Justice, and by weak, I mean in Thai context, the Court of Justice is long known to be quite lenient or complacent to the government, quite deferral. So, as for example, for this round of lockdown and all the measures, there's a few attempts to challenge in the Court of Justice that the government's order is arbitrary and capricious, and the Court of Justice simply defer to the government that it is necessary to control the pandemic. My my another point is that so how we use the Emergency Act in 2020 to control COVID is quite novel in our constitutional norm. Usually, as I mentioned earlier, that is used to control the crowd during the riots or the insurgency, and I mean, it's a necessary measure to take away some of your rights and liberties. This time, actually, we have more than 40 laws to use to control pandemic, but the government refused to. And part of it is because of the coalition government of more than 19 parties, means that the cabinet couldn't work in unison with various laws. So instead, the Emergency Act is used to bypass all the minister and give the prime minister total control of the situation. So actually, it's not about right and liberties. It's about right and liberty as much as about the government's incompetency and the government try to find a new way of public administration, and also just to give them a almost virtual impunity. So that's pretty much my my points on the situation, and I think I have already expired my time. Thank you very much.
Thank you so much, Kem. You are right on time, 5 minutes exactly. That's fantastic. And I think you make the really important point that must be true in all cases, but it's worth spelling out that the emergency powers and the response to COVID-19 rest on what was there before, and that the public response to a declaration of emergency is conditioned by past experience, which in Thailand is that kind of experience of authoritarian government. Great, thank you. So our third case study is Timor-Leste, and I'm delighted to welcome Professor Ricardo Sousa de Cunha, who is a professor of law at the University of Minho, and he's a former legal advisor to the president of Timor-Leste. So Ricardo, I invite you to give us your 5-minute presentation on Timor-Leste.
Thank you very much, Anna, and thank you all for listening in. I'll try to be brief, but please let me know if my 5 minutes are up. The case of Timor-Leste is a particularly interesting one regarding the topic at hand, the use of emergency powers, and particularly the representative control, because the pandemic found Timor-Leste precisely in a parliamentary crisis. The parliament failed to approve the state budget for 2020, and in that sense, earlier in the year there was a political crisis. The main party of the existing coalition first asked for new legislative elections, later found a new majority in parliament. And this was precisely at the time when the pandemic of COVID-19 was declared, and the first case was registered in Timor-Leste. So, so the first measures adopted in Timor-Leste were adopted in this context, in the context of a political crisis, which led to some confusion. But overall, the lesson is that it did not prevent the adoption of the measures necessary to fight the pandemic. It did not prevent the declaration of the state of emergency, since its declaration involves all organs of sovereignty. It's requested by the government, but it's authorized by the parliament and declared by the president. And the fact that there were different majorities represented in each of the powers did not prevent the adoption of the state of emergency, and it did not prevent also the adoption of the necessary measures to fight the economic consequences of COVID-19. However, it led to some confusion. Some of the measures adopted by the parliament were not necessarily those that the government had asked for and found necessary to fight both the pandemic and its economic implications. But in any case, things worked out, and interestingly enough, the rearrangement in the parliamentary organization, the majorities that the parliament finds, a new majority was found to support the government, the existing government, which has since led the fight against the pandemic and its economic consequences ever since, and has even determined the formation of a new government led by the same prime minister, and the adoption of the state budget for 2020, at least they're discussing now, and also it's foreseeable that the budget for 2021 will again be discussed and approved, and so the new political stability has been found. On the other hand, this government in full force has sought the adoption of legislation to overcome the state of emergency. The government proposed legislation that would grant it the powers that it needed necessary, that it found necessary to fight the pandemic, namely the possibility of declaring of controlling the borders, which is in island states particularly important, and also quarantine measures for incoming travelers. However, some of these measures were declared unconstitutional by the Court of Appeal on request of the President, which is a preliminary ruling, if you would like, and they were found unconstitutional precisely because the court found that it was the competence of the national parliament, but the national parliament, which was in recess, did not adopt the necessary legislation. So, as we speak, the declaration of a new period of state of emergency is being discussed precisely today. The renovation of the state of emergency with some limitations to the freedom of circulation, particularly precisely for these main two reasons. On the one hand, the control of the border. On the other hand, the quarantine powers. So the last idea that I wanted to let you know is that, like the previous intervener stated, it is very much to the national parliament the discussion and the authorization of the state of emergency. But it would also be interesting to discuss what it is that the administrative powers, the government, do irrespective of that. And I believe that is a tension in the separation of powers that we find everywhere, and that is also I think interesting to look into. So thank you very much. I think my 5 minutes are out.
Fantastic, thank you so much, and such an important point to end on too, about the range of agencies and authorities that are involved, and I think this makes the theme of representation kind of more important. It's not just Parliament that is a representative, it's the administration, it's the President, it's potentially the courts, the media and others. So I think it was really, really helpful observation at the end. So our fourth speaker is Professor Maria Ela Atienza. She's from the Department of Political Science at the University of the Philippines, Diliman. And Ela hosted the second Melbourne Forum in 2017. And it's wonderful to welcome her to this Melbourne Forum. So please, Ela, your presentation on the use of emergency powers in the Philippines, please.
Thank you, Anna, and thank you to International IDEA and Constitutional Transformation Network for giving the Philippines another chance to present its case, particularly when it comes to emergency powers in this period. So generally, in terms of mechanisms used to handle COVID-19 challenges, both at the health and economic front, in January, we had the first imported cases, but it was in the first week of February that the government was forced through public pressure to impose travel bans and to start voluntary repatriation of Filipinos in affected areas abroad. And then in March, after the first 3 cases of local transmissions, President Duterte declared a state of public health emergency in the country. And this is actually based on constitutional provisions and the law on reporting of communicable diseases. And then in March, a partial lockdown of Metro Manila, as well as a ban on travel in and out of Manila was imposed. And on March 16, the entire Luzon group of islands was placed under enhanced community quarantine. We would later learn that this enhanced community quarantine would be the most or the strictest form of lockdown in terms of the many types of lockdown that the government started introducing. So on March 16, the president signed a proclamation placing the entire country under a state of calamity, mainly due to COVID-19. And this is supposed to take effect for 6 months. So it has until September 16 this month, and we don't know if this will be extended. Again, this is based on constitutional provisions as well as the Philippine Disaster Risk Reduction and Management Act. After May 15, there was a gradual easing of the lockdown in certain areas, and the declaration of lockdown became localized depending on the number of cases. The main goal of trying to ease the lockdown is to actually enable economic recovery, because as I will show later on, the Philippine economy has definitely suffered as a result of the pandemic. In terms of legislation, in the last few weeks of March, the 2 houses of Congress approved what we call Bayanihan to Heal as One Act. This was signed into law by President Duterte also in March, and the law gave the president some emergency powers for 3 months to optimize efforts in the pandemic response. And this involves not just strengthening the public healthcare system, but actually reallocating the budget to deal with the pandemic and to provide support for those dislocated. However, the Bayanihan Act expired this June, and right now Congress has passed what we call Bayanihan 2, which will no longer give the president emergency powers, but it's a big recovery package. In terms of impact, on the positive front, there were some improvements in strengthening the healthcare system, but right now, because of the opening up of certain sectors of the economy, the Philippines is now the #1 in Southeast Asia. We have more than 200,000 cases in total. So that means that there's a lot of work needed, even if they had emergency powers. The contact tracing and testing have not been done properly. And economically, the effect of the global pandemic and the lockdown on the Philippines was tremendous. And we're now experiencing the first recession in 29 years. As I said earlier, the temporary emergency powers are based on the Constitution. This was the first time that the emergency powers were granted to the president because of a national health emergency. But under the 1987 Constitution, there were other crises before, at least 4 times where emergency powers were given to the president. There were no other forms of emergency powers used as of this time. The legislature, of course, is involved, particularly in passing the legislation that granted the president emergency powers. It, of course, has oversight functions, but based on our earlier study on the constitutional performance of the 1987 Constitution in the time of the pandemic, we found out that despite these oversight functions of Congress, it seemed that it has not exercised enough due diligence to actually look into whether things were done properly or things were done right before approving this second Bayanihan law. At the same time also, we also see how executive power has really been dominant in the absence of very strong political parties and in the absence of weak minority in the two houses of Congress. Of course, there are other areas that can perform oversight. The local courts have been very busy, particularly in looking into the implementation of the lockdown procedures. At the same time, of course, anybody is free to petition or file a case in the Supreme Court, but this is a big challenge for the Supreme Court because for those of you familiar with the Philippines, you have seen how the Supreme Court in recent years, because of the removal of our Chief Justice, it has become less active in terms of acting on these issues. There are also some we're also waiting for the Commission on Audit to look into how the finances were actually used by government in the exercise of emergency powers. There are some worrying trends because throughout the period of emergency, the executive branch, rather than focus on the pandemic, has continued attacking critics, removing or not giving franchise to the biggest media company in the Philippines, and that has affected the issue of access to information, and the anti-terror law was passed during the period of the pandemic. So this, and I think the VDEM Pandemic Democratic Violations Index and also IDEA's new COVID-19 monitor already pointed out some democratic backsliding on that part. So I think to sum up, positive or negative lessons would be, of course, this shows that we really need to focus not only on legislation, but reforms in strengthening our legislature, our judiciary, and of course, our oversight institutions, as well as people's access to correct information. But in terms of positive lessons, I think an important aspect of the pandemic is that we see more people that are actually monitoring government performance. Local government units are moving up and actually doing their best. And there is now increasing focus on trying to pressure the Supreme Court to act on cases of abuse on the part of the government, and concern for a lot of people to make sure that the 2022 national and local elections will push through despite the pandemic. Thank you very much.
Thank you so much, Ela. Such a rich picture of what's going on in the Philippines. So thank you very much. And again, many themes that we'll come back to, I think, during the discussion. So our fifth and our final case study is Japan. And I'm very pleased to welcome Kimitoshi Yakubi, who is a lawyer in Japan and a member of the Democracy for the Future project, and a member of several other institutions for the promotion of the rule of law. So Kimitoshi, I invite you to share your presentation on the emergency powers in Japan.
Thank you very much, Anna, and everybody. And I'm very glad to be invited to this very remarkable opportunity to present the Japan situation of the COVID-19. And I will show you my presentation. Just I try to limit my presentation within 5 minutes. Okay, just 5 pages. And main points of our presentation is here. In Japan, there is no provision which grants emergency power to the government in the Constitution. The Constitution doesn't allow the government to have the free hand power to deal with the emergency situation. Instead, Japan has dealt with this COVID-19 situation by way of amendment to the existing laws, the Infection Disease Control Act, and also influenza-related laws, which the government tried to include the COVID-19 in this scope of these laws. And of course, the Diet passed this amendment of the law. And the Amendmenting Act granted a limited power to the national and municipal governments to issue a declaration of the emergency situation. But that declaration does not enable the governments to issue the lockout order, violation of which shall be punishable. So we don't have any power to be given to the government, the lockout order. The term is also limited. Even though the government issued some declaration of the emergency situation, the term should be limited to 2 years with the extension for up to 1 year. Municipal governments can request the people to stay home, but as I said, this is not the lockdown. That is only a request basis. The Constitution requires the governments to compensate if it regulates the private property and businesses, so that the government pays to the businesses from which the government requested to limit their operation. So government has to pay if they request the businesses to operate in the limited way. The democratic review has been made by the government through reporting requirements to Diet, and more importantly, the municipal governments discussed the measures with the national governments very heatedly, which I think secure the transparency to the large extent. Of course, lots of media is very important and crucial. The issue is balancing between the prevention of the diseases and the continuation of the economy, which is a large concern among us in Japan. The first, as I said, early February, COVID-19 was designated as one of the infected disease under the Act. And also the existing law include the COVID-19 as applicable diseases. And that legislation was done through the usual Diet procedure, but without objection from any opposite party. Very rapidly they passed the law on March 14th. The amended act sets forth the laws of power to both the national government and the municipal governments, including request people to refrain from going out. As I said, this is not a lockout, just a stay-home request. Even under the amended act, the government is not allowed to issue the lockout order, as I said, with the punishment or the fines or imprisonment. No power is given to the government in Japan. The Japanese government announced the declaration of the emergency situation on 6th April, and enforcement started from 8th of April with respect to the 7 prefecture, limited part of Japan, including Tokyo and Osaka, big metropolitan areas, declaration covered. Declaration was until 6 May. However, on 16 April, the declaration was expanded nationwide. So from 6 the declaration is part of Japan initially, but expanding to nationwide. But the finally that declaration was terminated in 36 prefectures earlier to the deadline, and the end of May it was eliminated totally on all the prefectures, including metropolitan areas. It is too early to evaluate if the measures carried on by the Japanese government have worked well to prevent COVID-19 from prevailing further, while also sustaining the national economy. The number of the infections in Japan has been increasing. Of course, the number of the deaths is not so large, but still the patient number is increasing. The Constitution does not grant the emergency power, as I said. And they discussed at the Diet whether they need to amend the Constitution, but the opposition party and the media commented that such constitutional measure could grant unlimited power to the government, and the abuse of such power may cause unremarkable damages against the people's interests in the future. So the current Constitution, Article 96, sets forth that the private properties may be taken for the public use upon just reasonable compensation. the government therefore implemented a special payment to the businesses, as I said, which complied with the consent request on their business operation from the government. The amending act provided that the measures taken by the government should be reported to the diet, not the approval from the diet, just a reporting requirement under the law, because measures should be implemented very swiftly. It seemed to have worked, partly because I think there are always discussion between the national government and the municipal government, and the governors eloquently discussed with the national government how to implement the measures, which has ensured the large extent the transparency regarding the argument for the for against the different measures taken by the national government. In Japan, the court has not been involved in the oversight of the measures taken by the government. Of course, if the property is taken by the government, that individual cases can be brought to the court on an ordinary procedure. Importantly, the media put huge attention on the COVID-19 infection, as every country does. And its law, the media's law, seems to have secured the transparency of the government measures too. So finally, I personally think that the constitutional measure enabling emerging powers is not necessary in Japan. If the situation becomes worse, we may need to further amend the current laws to incorporate the stronger measures to be taken by the government at the national and municipal level. As I mentioned earlier, my overall analysis of Japan approach to deal with the COVID-19 pandemic is positive, even though the measures taken were not as strong as those which other countries took, in particular the use of lockdown orders. In any event, supervision by the diet or other constituents is necessary. In Japan, local governments have taken such laws to the large extent, as I said. However, the reporting requirements set forth in the amending act should be provided in more detail, and the role of the judiciary should be stated in the amending act if any measure taken by the government impedes the freedom people. The last week, freedom media, still very important role in Japanese society. So that is my presentation. Thank you.
Thank you so much. And thank you to all our panelists for giving us such a rich insight into the way that 5 countries in our region have responded to the COVID-19 emergency. So now we'd like to open this up for discussion, which is one of the most rewarding features of the Melbourne Forum, but also one of the more difficult aspects to replicate online. So to manage this as best we can, we have different Zoom instructions for our invited experts, our panelists, and for our observers. So for our panelists across all of the 4 sessions, I invite you now to please switch on your video so we can all see your faces as we have a discussion. But please keep your microphones to mute unless you're speaking, just to avoid some of the background noise. And again, just a reminder that the discussion is recorded. So if you don't wish to be seen, please turn off your video. You're welcome to contribute to the discussion. We invite you and welcome you to ask questions of the panelists, share insights and experiences from your own countries, and draw out common themes and issues. If you haven't spoken before and when you first speak, you could briefly introduce yourselves, that would be good too. We can start to get to know each other. So yes, for those of you who are observing our attendees, we want to include you in the discussion as well. So please type your questions or comments into the Q&A box in Zoom, and I'll read your questions or comments aloud to the panelists for their response. So we might take a few comments and questions together and then give our panelists more time to respond as we go. Sorry, so Amanda, did you want to start us off with a question?
Sure. Thank you so much, Anna, for the opportunity. It's a really excellent panel. I actually have two questions, if I would be allowed to ask them. The first is really actually a point that was made at the end of Ricardo's paper on Timor-Leste about how, the declaration of emergency under legislation as opposed to the Constitution, maybe criticized in some ways, but also avoided the need to institutionalize expanded powers for the executive in a time of constitutional normalcy. So I'm wondering how much that was discussed in other countries. For example, also Japan, of course, there isn't the possibility of declaring a state of emergency under the Constitution, but that was considered, I know, to have constitutional amendments that would allow for that. And then it was decided not to, I think in large part because of this risk of institutionalizing expanded power. So it's kind of a question for all the panelists. I'm just interested in whether this was discussed in countries and whether the use of legislation, also in the Philippines, was preferred to constitutional change or constitutional declarations of a state of emergency that might have allowed for more permanent expansions of power. And slightly related to that, I'm also interested in what's perceived as a rights violation in the different countries. I thought that was really interesting. That came up in the papers. Again, to take, for example, Japan, that this issue of businesses and compensation, and that was actually a really big, considered a rights issue, and therefore a limitation on the ability of the government to pass certain restrictions. Whereas in Timor-Leste, you know, it's very focused on freedom of movement. So just like looking at the different, what is considered and what constitutes a rights violation in the different countries. Thank you.
Great, thanks, Amanda. I might take another comment from Cheryl, and then we'll go back to the panel on that. Cheryl, are you there?
Yeah, really just waiting until the ice has been broken for discussion. But let me just make one comment and two questions. I was really struck by these 4 countries, where all of which had provisions in the constitutions dealing with emergencies, but they are so different. You know, they're so different that you almost get sort of lost in the detail trying to sort it out and think through what a appropriate 21st century constitutional emergency power might look like. And I think that it's a wonderful set of papers from that point of view. And it'd be interesting really to know where the inspiration for some of those formulations came from. But I've got one question for Georgina and one question for Kim. Georgina, your discussion of the emergency provision in the Solomon Islands makes it clear that the power lies with the Governor-General. Well, that the Governor-General formally exercises the power. And in your written paper as well, you talk a lot about the Governor-General. At one point, you do say, of course, the Governor-General normally acts on the advice of the government. And I've been assuming that in this case, the Governor-General did act on the advice of the government. But I just wondered how much accountability and upfront responsibility the government took for the declaration that the Governor-General made in Solomon Islands. You know, how did all of that actually happen? And Kim, I was struck both in your presentation and in your paper by the distinction you draw between there being no emergency power in the Constitution, but there being an emergency legislative power. I mean, I looked at your emergency legislative power. In fact, I made a little collection of all of these constitutional provisions. And it seemed to me to be a pretty potent power. And so I wondered where you draw the distinction, exactly what distinction is being drawn there. Thanks.
Great, thanks, Cheryl and Amanda. I think they're both quite related questions on you know, the use of, you know, the preference for constitutional or legislative mechanisms for a state of emergency. So maybe our panelists would like to respond to those questions, Georgina and Kim in particular, but all panelists as well on Amanda's points. Would you like to go first, Ela?
Oh, yeah, okay, thank you, Anna. Regarding Amanda's questions and also Cheryl, of course, in the Philippine Constitution, emergency powers can be granted, but the Constitution specifically stated that Congress or legislation is needed to grant emergency powers. And of course, the reason behind this need for a law to give emergency powers or temporary emergency powers to the president is, of course, based on the context of the writing of the 1987 Constitution, which was, of course, a product of the 1986 people power and our experience under martial law and authoritarianism. So the constitutional provision on granting emergency powers to the president is only temporary and at the same time has to be granted by Congress. At the same time, there were also some legal experts who questioned the generosity of our legislature to give too much powers to the president, when in fact they said this could have been a last resort. Congress could have created a supplementary budget so that the president will no longer need emergency powers to reallocate the existing budget to the pandemic. There was actually an attempt by one petitioner to bring the case to the Supreme Court at the beginning of the approval of the Bayanihan Law. The argument was the Bayanihan Act was unconstitutional because it was based on undue delegation of legislative power to the president. However, the Supreme Court dismissed it on the grounds that the respondents failed to show grave abuse of discretion. So in that sense, the law itself, the Bayanihan Law, is constitutional, but of course it does not prevent anyone from actually questioning the constitutionality of actually carrying out the emergency powers. And regarding the question about what rights are important even in the period of emergency powers, the Bayanihan Act actually did not invalidate the Constitution or any of its provisions. This include the operation of the Bill of Rights and other constitutional guarantees. And this is always the issue with many groups who argue that in the implementation of emergency powers, there was too much emphasis on the peace and order aspect, and this may be due to the fact that many of the implementers, many of the heads of the crucial agencies in fighting the pandemic are former military men. And so their mindset is more on looking at the pandemic as a peace and order problem rather than a health crisis. Thank you.
Yeah, really interesting. Kimitoshi, did you want to speak in response to Amanda's question? I think Japan has some interesting insights on the rights one in particular.
Okay, thank you very much for your question. And in responding to your question, I have 3 points I would like to talk to you. One is our constitution has not been amended for more than 70 years. So people are very worried about the amendment of the constitution. So that is one reason. And secondly, more importantly, even if the government tries to circumvent the constitution by way of the legislation level, the law making, the constitution is also always upper side over the legislation. So if the new law, amendment of law, violate human rights or any rights under the constitution, people can bring a case to the court saying that our rights or the ownership of the properties are damaged by the new law. So that is a kind of the way to prevent the government from having excessive power. And thirdly, our system is a parliamentary system, not the presidential system, so that the cabinet, including a prime minister, are not independent, always responsible to the Diet. So the Diet can have the more power than the government, so that the Diet at this moment, Diet say that we don't want to let the government have the free hand power over the emergency situation. So these 3 reasons, I think, Japan are very reluctant to amend the constitution to include the emergency power to the government. So as I said, the payment to the people whose property are damaged, that is a very sensitive issue and very heatedly discussed at the Diet and also the society by way of media attention. So that is one of the example the people discuss how to restrict, how to secure their property rights or human rights, including freedom movement. So that is the situation in Japan. Thank you.
Fantastic. Thank you. Ricardo?
Thank you very much, Anna. I would like to thank the questions, and also I would like to try to connect particularly Amanda's comment to a question that was posed by Professor Canelas de Castro on the Q&A, because that is a very interesting point, the different ideas on the restriction of fundamental rights, particularly with the state of emergency. In Timor-Leste, which is a civil law country in the, if you like, Portuguese-speaking countries tradition, because it was formerly colonized by Portugal. The state of emergency is adopted with the intent of restricting fundamental rights for a particular period of time, limited. So that is its main purpose, if you'd like, suspending some of the provisions of the Constitution for a limited period of time, and it is for the government to implement the measures necessary to overcome the situation that determines the restriction of these rights. I would like to connect this to the question that Professor Canelas de Castro posed on the Q&A, because in Timor-Leste, this was not, I believe, sufficiently discussed by the court when it was called upon to decide on the constitutionality of the measures of the government. The court adopted a formal criteria. It determined that it was for the national parliament to legislate on the restriction of fundamental rights outside of the state of emergency situation, or apart from this situation, but I would have liked the court to discuss more thoroughly the degree of governmental intervention in this case without parliamentarian authorization. Because the government obviously has some competences that do not go into people's fundamental rights, and I would have liked the court to discuss this further. Matters of public information, even vaccines. Those vaccines, if they're mandatory, they can also restrict on fundamental rights, but public information they do not. So the government could have adopted these measures irrespective of parliamentary intervention. The court chose a blanket explanation, and it's up for the parliament to decide this. Of course, that it's understandable, particularly in developing countries, because it's a more formal procedure. But in any case, it would have been interesting to discuss this. Going to another of Amanda's point. Because the fact is that otherwise the state of emergency becomes the new normal, and we are looking into some countries that have declared state of emergency for 6 months, and some of them almost a year, and it's necessary to deal with these new challenges, also testing the limits. Otherwise, we'll be living in permanent emergency, and that's not also what we expect. Thank you very much, Anna.
Sure, thank you. Kem, I wonder if you want to come in next, both on the general points that were made, especially about the idea of a state of emergency as a normal in Thailand, but also on the question that Cheryl had.
Right. Okay. So just give you some statistics. Some part of Thailand has been under the state of emergency under the Emergency Act since 2005. So it has been already 15 years. So it has been a normal part of life in many regions, especially in the southern Thailand. And I mean, I experienced it in 2006, in 2009 and 10, and 2013 and 14, and 14 last until 2015. So I mean, a lot of, even in Bangkok, we have been under that the measures for quite some time. And interestingly, despite the length that we have used the Emergency Act, there is no precedent about what deemed as violation of rights and liberties. It seems that the emergency legislative power, once you use it to promulgate the Emergency Act, the sky is the limit. I mean, there's some court case in the Court of Justice, but it doesn't challenge the order or the act itself. It's just an abuse of power, or the government employee acting outside virus. So it's fall within the criminal law area. So but that is very, very few. I mean, we have a tendency to defer to the government to exercise its discretion and say what is emergency and what is a suitable measure for that kind of emergency. So actually, despite it has been in place for 15 years, the sky is still the limit, and the government enjoy vast power. And okay, so back to Cheryl's question about what's the difference between legislative emergency power and Emergency Act. And the emergency legislative power is actually more broader in purpose and how we use it. In the past, it's used for some financial emergencies as well as other legislative emergencies. If you, I didn't provide all the use in the past, but for example, during the 1997 economic crisis in Asia, they used this emergency power to promulgate a series of acts to secure loans and to accept the term from International Monetary Fund, from IMF. So it's not anything about national security or with public safety. It's just to because the matter is urgent and they bypass the normal legislative power. And that's how we use it in the past to amend the excise tax, to amend the criminal code, for example. Why it's very different? It's so different with this Emergency Act because it's specifically about national security. So that's the main difference. Yeah.
Great, thank you, Ken. Georgina, did you want to comment on any of the broader questions, but also Cheryl's question about the role of the Governor-General in Solomon Islands?
Yeah, thank you, Anna. I think I'll go to the question on the by Cheryl. Thank you for that. Solomon Islands, as some of you might know, it has the Westminster system kind of governance. So we have the Governor-General representing the head of state, which is the Queen. So usually during emergency powers, the Governor-General will make the decisions on the state of, or if the country need to go in a state of emergency upon advice from the government. So which is why I mentioned the Governor-General a few times, especially in my in our article. And then this is the first time for Solomon Islands having such state of emergencies. Like usually it's for a state of emergency, the span of duration is 4 months. So 4 months is the span of duration for the state of emergency. So when one ends, there has to be another state of emergency. And this is the first time for Solomon Islands to come across such incidents. And it's quite new, especially for the people as well as the government. And we've asked questions surrounding, like, is it really necessary that we have the state of emergency? Like, we have the laws already there. We have the quarantine laws, the immigration laws. Why don't we just suspend some of those laws in there? But then the Attorney General said the laws are not proactive, they're reactive, in a sense where people or those who come into the country has to have a disease or coronavirus in order for them to be quarantined, not proactive in a sense where they have to be quarantined even without COVID-19, because it will go against the fundamental rights of the people. So basically we have a lot of Solomon Islanders residing outside, and they need to come back into the country, especially those students, some who wants to come back to the country. So we need the state of emergency laws in order for them to be quarantined. So which is why we still have the state of emergency. So we have repatriation flights coming in. Just recently, we have one from China that arrived last night. We have a few nationals on board, as well as some Chinese nationals who are Solomon Island citizens. So Solomon Islands as a country without any COVID-19, the government says that they are trying to do these things in order for us to keep COVID-19 out. So basically, that's what it is for us in Solomon Islands, especially with state of emergencies. And then now the second one will lapse in November, and now a new law is in the making. This is for a Public Health Emergency Act, or a Public Health Emergency Bill is now being looked at by members of the Oversight Committee again. So this is in the making. They hope to complete this by November 25, which is the time when the second state of emergency will come to an end. So it's quite a new thing for us in Solomon Islands, especially coming back to human resources. As I've mentioned earlier, the Attorney General's chambers, we really do not have a lot of legal draftsmen. Also in the Attorney General's chambers, mainly they're just young workers, students that just graduated and have come back and are now working in the Attorney General's chambers. So it's quite a small number when it comes to human resources, and when it comes to dealing with laws and writing up laws, we don't really have a legal drafts person that works full-time for the government, unless we get consultants or overseas and all that. So yeah, that's from Solomon Islands.
Yeah, great, thank you. And it's a familiar story, I guess. I mean, there's not just one emergency power, but there's legislation and regulations proliferating in all of these states as governments try to manage it. So just a reminder to our panelists, so if you want to ask a question or make a comment, just raise your hand in Zoom or gesture at me like this, or drop a comment. I have a question from the broader audience, and it's that they ask whether the panelists could share their insights on the appropriateness of the powers of competent courts for reviewing the constitutionality of emergency legislative or executive measures in times of emergency. So this is something Ricardo has already briefly mentioned, and several others as well. And they've asked, do executive measures constrain the court's capacity? So I put that question to all of the panelists, and Kamana has a question as well. Kamana, if you want to briefly introduce yourself before asking a question.
Thank you so much. My name is Kimana Zuleta. I work for International IDEA. Currently I'm head of a program that supports constitution building in Myanmar. So I'm based in Yangon. My question is perhaps a bit related to the question that Amanda asked before about the difference in state of emergencies and constitutions and legislation. But I'm particularly interested about the impact of the policies undertaken to deal with this pandemic on the nature of political parties. And I wonder whether there are any new political movements or political parties running their programs or even campaigns on legislative or constitutional reform in this sense, and also more broadly picking on popular sentiment against government policies of using either the constitution or legislation to increase their own emergency powers. And then I also wonder what the strength is of these political movements, if there are, what the strength is, and are they increasing in strength? Of course, we know that in Europe, in many European countries, there are increasing right-wing political movements protesting against government policies, and I just wonder how it is. Thank you.
Cool, thanks, Kimana. I might just leave those two questions for the panel now. So I think they're quite nicely related. So really both are about institutions other than legislatures and executives that kind of emerge and have a role in these emergency times. So one about the role of courts and the other one about the role of political parties and perhaps even grassroots movements. Would any of our panelists like to tackle these first? Just jump in. Yeah, Kem, thank you.
Okay, thank you. So I already mentioned that the Emergency Act prevents the administrative court, which we deem like very capable and very progressive, from reviewing the act of the executive right now. So all the cases go to the Court of Justice, and they are not very successful. They are all thrown out by the court and right away. So I think that's for the first question. Yes, the judiciary has been constrained by the executive, but it's very notable that the court has never put up a fight or attempt to expand the power, and that has long been known, and that's part of the reason why the Prime Minister want to have a judicial review by the Court of Justice in the first place. And I think it's still true today that the Court of Justice never tried to expand or be more aggressive. But from Kimana, I think that's very interesting, because right now Bangkok and actually Thailand is still under the emergency decree, and what happened is that by late June we already know that there's no local transmission, and we are demanding for some relaxation or lift the emergency decree, and actually the government keep extending it until right now. They keep extending it once, like a month at a time, and right now we have it extend to the end of September. So by 18th of July, there's a small flash mob. It was intended to be small flash mob against the emergency power, but actually like thousands of people showing up, and that's quite remarkable, because we have been under the military regime for 6 years, and the past year under the new government, it's not free at all. It's very authoritarian. So that flash mob is a start of many other things. So right now we have protests in almost every, I think 73 out of 76 provinces in Thailand has some form of protest going on. The largest one is in Bangkok, and it goes beyond the issue of emergency power. I mean, we regard emergency power as symbolic of representative of a much larger problem of military in Thai politics and authoritarian system. So now they are demanding a change of constitution, and the government has to resign, and actually they even asked a reform of the monarchy, which is something like 3 months ago it was unthinkable, and now it's like very real. Like the demand is very real and has certain implication on the institution right now. Thank you.
Interesting. Do any of our other panelists? Yeah, Kimitoshi.
Yeah, thank you very much for your questions. And two questions are very interesting to me. One is the role of the court. As I said, we don't have the constitutional court system. We do have only a normal court system. And also the court procedure takes a time. Under the current emergency situation with COVID-19, people do not expect the court to work actively to prevent the excessive power of the executive branch from doing more excessive the implementation of their power. However, if the people's rights, including property rights, is damaged by the emergency measures, the people can bring the individual cases to the court. However, I don't know any case which is brought to the court. It is said that the Japanese people tend to obey, comply with the request from the government, and they do not complain about the governmental measures. So under the current situation, people tend to agree upon the measures taken by the government. So the Japanese society is very subtle. The government issued a request without any punishment. Request which is not the order, just a request. And the people tend to comply with the request, not asking for the compensation. But the government voluntarily agreed to pay some kind of monetary compensation to the people, which is not a requirement under law. So that request basis and the voluntary acceptance of their request is a kind of nature of the Japanese society. So the secondary of the political party's role, I think this is very, very important to secure the governance of the executive branch. As I said, the Japanese system, the parliamentary system, the cabinet, including the prime minister, is responsible to the parliament. But under the current situation, Japan, the largest governing party has a large part of the parliament membership, so that the opposition parties are very weak. So under the current situation, even under the current situation, opposition parties' role seem to be very limited. So that worries me very much. I would like to have the opposition party stronger than now. Interestingly, last week, Prime Minister Abe said that he will resign in September, so that some political movement started, but still the governing party is very strong, and people do not expect the opposition party to work as a watching role, watching dog over the activities of the governing party. So that is an issue we face now in Japan.
Great, thank you. Ela.
Yes, thank you, Anna. Yeah, let me answer the two interrelated questions. The first one regarding the, well, it's regarding the role of courts and to follow up what I mentioned earlier, the constitutionality of the law that granted temporary emergency powers to the president has already been dismissed, but in the process of the government's exercise of emergency powers, as well as its overall response to COVID, some trends that we are watching is that right now, with the swift passage of the Anti-Terror Act, the Supreme Court is now inundated with more than 20 petitions to declare the law as unconstitutional, and there are questions about the process in which it was passed, even during a pandemic. So we're watching the court in that case, how it will resolve that. And another related issue with the emergency powers of the president and overall government response to the pandemic is that there is now a demand for the Supreme Court to review its decision to dismiss a petition calling on the people's right to know the health situation of the president, because there are issues related or concerns related about the actual state of health of the president, which might actually affect his performance of his functions, particularly during this period. And it's also constitutionally guaranteed that people has a right to know when the president is experiencing any grave illness. Regarding the impact of these policies in relation to the pandemic on political parties. Even before the pandemic, there were already efforts on the part, not just of the government, but also other sectors pushing for amendments in the constitution, focusing on strengthening political parties and reforming the electoral system. That these are issues that are still considered important, but because of the pandemic, using constitutional amendments may not be the immediate concern of many people, but there is still a push to create ordinary legislation that would actually strengthen political parties and also to reform the Party System Act. What is evolving now is that there are now efforts on the part of certain groups to use direct democracy or referendum first in granting franchise to the large media giant, which was the denied franchise. But there are certain worrying concerns as well. Certain groups that are supportive of the president are also calling for revolutionary government. And at the same time also, it's weird, but they are calling for a revolutionary government to be headed by the current president. And at the same time, calls for the president to be granted temporary emergency powers to deal with corruption in the public health insurance system. Thank you.
Georgina or Ricardo, did you have anything to add on this point that you wanted to respond on political parties or the court? I know Ricardo's already mentioned the court.
Yeah, thank you, Anna. I think for Solomon Islands, I can just give an example from Solomon Islands, the issues which we have. I have mentioned some, especially in the article about the court releasing those arrested for especially during the lockdown or curfews, simulated curfews being organized by the government. And then one of the orders which was mentioned by the, which was made by the Prime Minister was the spread of rumors. And just last week, we had one person who was charged with spreading of false rumors. He claimed on his Facebook forum, he has a forum, that Solomon Islands has confirmed cases of COVID, that was sometimes in the middle of this year. So he was charged with spreading of false rumors, but then just last week, or was it this week? This week, the court released him saying there's no case to answer. So you can see how it's like, especially with the emergency powers, there's the orders and then there's the court decisions, which shows that there's something not connecting actually. And then we have the new public health emergency bill, which is currently in the making. But one thing about it is that the oversight committee that consists of the permanent secretaries in the government ministries, they'll be the ones looking into the drafting of the public health emergency bill. So actually for Solomon Islands, like it's something which people are just looking and not really saying much about it because not everyone understands the law, and then we do not have the capacity, nor do we have the people with expertise and knowledge in here who can be able to speak on the issues for people to understand better. So we really are sort of in a kind of a situation where the media also is trying to understand and trying to get the right people to answer. But it seems that if you want to get people to speak on the issues, especially when it comes to laws, we have to seek outside, like overseas, get commentators from overseas to speak on the issues, especially when it comes to laws. Thank you.
Thank you. Ricardo, did you have any points on this one? And then we'll take some more questions and discussion.
Yes, thank you, Anna. Just very briefly, just to add on my previous comment on the power of the judiciary. I think that it's also one of the lessons to be learned from this is that the judiciary do have, in most cases, the last word, and their participation is also part of the control if you want, not representative, not elected in most cases, at least in the case of Timor-Leste, but it's also part of the control. But that also poses an increased responsibility on the discussion, as I said previously, particularly on the discussion of the limits which the government is allowed to intervene with or without parliamentarian control. Regarding the question on the political power, on the political parties posed earlier, as I said, it's interesting that the fight on pandemic found Timor-Leste in the middle of political turmoil. A coalition government was dissolving, and so the situation, the fight, the need to adopt measures to fight the pandemic facilitated, if you will, the overcoming of this political crisis. Parties were more willing to find new to build bridges, to find a new solution for government. Of course, that the biggest party of the dissolving coalition that is now in the opposition has protested exactly the opposite. It has said that the pandemic has been used as a rhetorical instrument to allow for consolidation of power. So you always have these two sides. We haven't had in Timor-Leste populist uprisings against the measures adopted like we have elsewhere. So things are in this case particularly quiet. Thank you, Anna.
Great, thank you. So I have a list now, which is wonderful. So Ramdas Manon, did you want to put your comment or question? For those who don't know him, Ramdas is going to talk to us about India, I think in a couple of panels' time. So welcome, thank you.
Thank you. So the panel I'm going to be dealing with is multi-level government. So my question has to do with this. Some of the societies that we talked about today, Japan, Thailand, Philippines, they're fairly large, complex political systems. So how does the declaration of the emergency, which is ostensibly under the central government in the center, how does that affect the relationship between the center and the peripheral governments? I know the paper in Japan talked about municipalities, but none of the other papers seem to have addressed the relationship between the center and the periphery. So I'm interested in how the emergency declarations affect their relationships, especially on matters related to fiscal issues, because what the pandemic has brought about is a double-edged sword. It's both a health crisis and a public health crisis, as well as an economic crisis. So I was wondering how that affects the relationship between the periphery, the center and the periphery. Thank you. Sorry,
yes, a really important question there, I think. So Akiko Ajima, did you want to ask your question? Akiko was a former member of the Melbourne Forum community. Hi.
Hello, Anna. It's Anna. Thank you very much for inviting me to make a question. And all the panelists, thank you very much indeed. It's so lively and so informative. And particularly, I would like to ask all the panelists about the sort of comparison between Japan and other countries. Japan obviously took the softer approach. So it is called as the declaration of state of emergency, but actually it's not the typical emergency declaration. In the bottom line, it's just a request without penalty. So why did it work? It's because of social pressure. Imagine if you go out without wearing mask, you immediately realize you're not wearing the mask because everybody see you and you immediately knew this is not right. So you go back to your home or you go back, just jump in the shop to buy a mask. That's the Japanese situation. So I'm wondering how far the same method can work in your own country. So softer approach might be possible in your country or it's not possible. And then if not, why it's not? So that's my question. Thank you.
Thanks, Kiko. I think it's an interesting question, and I sort of had a different way of framing a similar idea, which is not so much social pressure, but just I guess you know, having emergency powers is one thing, but implementing them is another. And so, how much do you rely on cooperation over coercion? And you know, and what does that mean? Does that require a certain degree of trust in our government and our representatives?
Distrust upon the government, because government did not do anything. So the citizens rather start to think, what can I do to prevent the infection?
Similar story in Hong Kong. Yeah, I regularly go out without a mask, and it's terrible. So yes, wonderful. So Bal Karma, did you have a question that you wanted to put to the group? Comment? I've lost Bal. Lena, did you want to ask your question in the meantime?
Yeah, sure. Thanks. No, I was just wondering about the longer term implications of these prolonged, extended state of emergencies, which have now taken place in democracies and non-democracies alike. We had Solomon Islands, where this was now state of emergency extended first time ever. And of course, we do have a case study or country case of Thailand, where this is a tool that has been often resorted to. But I do wonder about how do you see the longer term consequences, and do you foresee that there will be, at least in the democracies of this panel, some kind of a review process? Do you see the countries will revisit and review once this is somehow all over, whether there is a need to reform the legislation or state of emergency legislations, and how do we get out of these state of emergencies in the first place, and how do you see this role of representative bodies in this? If these state of emergencies continue and to be extended and extended, where do you see your role of representatives and representation and role of parliaments? Is it likely to increase, or how do you see how is this going to end?
Wonderful. I've just got a comment from a member of the audience that seems to be a little bit related to some of these questions, which is about how existing political, so the commentator says, the question says, the ways that existing political culture has conditioned the responses of the different constitutional systems has come through really clearly in the presentations. And this person asks, in what ways is the crisis then shaping political culture? So you've got culture shaping the crisis and the crisis shaping the culture. And, is there a hypothesis maybe that the normalization of greater executive power through emergency governance leads to a kind of permanent shift in the separation of powers, and whether you see that in your jurisdictions? And is it consolidating the power in a few leaders or parties, or is it really shifting that? So yeah, kind of crystal ball question to look into. Are there any other questions? Because if there isn't, I might just ask the panelists to have the final word from each of them on those points. Ella, did you want to go first? Or
okay. Very briefly, very interesting questions. Thank you very much. Regarding the effect of the emergency powers and the overall government response on multi-level governance and central-local relations, the Philippines is currently devolved. The previous proposal of the government to shift to a federal system or federal form has been shelved, but definitely the crisis has actually highlighted some of the things that have been happening even before the pandemic. Even with devolution, which started in 1991, not all local governments were able to assume many of these devolved responsibilities. And the initial months of the emergency situation highlighted the top-down relationship between the national and local governments. But as I mentioned earlier, one positive thing that happened here is that despite some of the uncoordinated responses and changes in national government response, there are emerging a number of local governments that have become more proactive. They were the very first in conducting mass testing, contact tracing, and they have taken what we call a softer approach in terms of implementing the pandemic responses of the respective localities. Even, for instance, the only regional government in the Philippines, which is the Bangsamoro Autonomous Region in Muslim Mindanao, has also responded positively here. Of course, the issue here is the fiscal transfers coming from the national government. So there is now increasing pressure to revise the local government code, which devolve services to devolve powers to local governments to make sure that a Supreme Court decision that will increase national government transfers to local governments will really be operationalized. At the same time, the issue about what should there be a balance between emergency powers and the softer approach, getting the cooperation or trust of the people. The national government has promoted a narrative that Filipinos are always violating laws and we lack discipline. But actually, based on domestic and international surveys, it turned out that more people are willing to follow quarantine rules and wear masks. So in a way, even the rallies of people who were protesting, people were actually practicing social distancing. So the point here is that it's important for government to actually acknowledge the role of people, because many people and civil society organizations and the private sector have responded positively to the problems created by the pandemic. I think it's important for government to change its narrative to actually make people more trusting and, as I said earlier, shifting from a more peace and order approach to a more health crisis approach. Regarding what is the future of the legislature and other representative institutions in relation with the executive power and emergency powers, I think at this point, particularly with the 2022 elections, in the minds of many of our legislators, even if they are allied with the president, many of them now are even in ongoing investigations, particularly with the Philippine insurance system. More of them are actually taking government to task and actually requesting government officials to actually resign or to face particular charges. And I think this will intensify as we reach 2022. Is the crisis shaping culture? More and more, as I said earlier, more and more Filipinos are speaking up and mindful of their role of people's participation and the right to speak, even through social media, and if possible, to organize and speak up when there are problems in government. Thank you.
Fantastic, thank you. I've just got my eye on the time, so we'll just keep these wrap-up questions a little bit shorter. Kem, did you want to say anything finally?
Right. So the situation in Thailand is okay. So we have the government for 7 years as a military government has already suspended local elections. So we don't have local governments in place. So we have only provincial governors, which is appointed by the central government. And that's very interesting because actually they are not acting on behalf of the people that they are looking after, but as a representative of the central government. And it's very clear because a lot of them issues more and more regulations on top of the Emergency Act to meet up the goal of zero transmission. So actually, that's the only aspect that the government cares, to have zero transmission. And every governors compete to have that goal. So what happened is over-regulation and over-zealous application of laws, and you get them going after like arresting people who like that more than 2 people gathering, something like that. So actually it's very bad for Thais to have that kind of governors going after you and try to limit your rights and liberty even more than the central government did. So that's one thing. So, and that's why I think what we are experiencing nationwide, like the ceiling has been lowered. So the new norm is that we're gonna be like in the deep south regions where emergency measures become new normals for the next 1 or 2 years, and that's why the protest is ongoing to fight against that lowering of ceiling. Like we have to push it back. We have to like keep it there. We don't want it to be lowered any more than what it is right now. And part of the reason why we have to protest is because in the parliament, the MP's oversight of the government is really weak. In February, the Constitutional Court had just dissolved one of the leading opposition party, and so right now the government has majority in the parliament, and they always vote in favor of the government. So that's why. So for securing the loan, 2 trillion baht, that's a lot, and for other measures, the parliament proved to be very useless. That's why the protest is ongoing right now, and that reflects in how we react or respond to the COVID-19 in the first place too. Like the government didn't declare border shutdown, didn't declare partial lockdown of the city, but everyone already knows, and everyone put on masks and try to monitor each other. And so if you ask me what the government is focusing right now, they use the Emergency Act to try to curb the protest other than to curb the transmission of COVID-19. And that's why like there's so many protests and fighting in Thailand right now. Thank you.
Fantastic, thank you. Kimitoshi, did you want to take a couple of minutes to respond so we can get done by 4 o'clock?
Yeah, thank you very much. Thinking about the time constraint, I cannot respond to all the questions, but I'd like to respond to some of the questions. And first, soft approach, Akiko mentioned. I agree with her that the social pressure is prevailing among the people in Japan. And sometimes people criticize each other, as I said, not wearing the mask on the road. And also people defame the medical, the service providers, including the nurse and doctors, as well as their families. They discriminate their families at the kindergarten or schools, which is not good to the society. And also people tend to think that the authoritarian regime may be better because that is effective and efficient more than a democratic system. I disagree with that opinion. And the issue is civil society. How to strengthen the civil society? The last point I heard, that is cultural change. I'd like to have this situation be the opportunity to change the civil society in Japan. We, Japan, need to strengthen our civil society more. People tend to rely on the government in the past. But from now on, we need to strengthen civil society, that each person, each people, all of the people should decide by themselves what the best measure they need to implement and how to select their legislatures in the diet. That is, I think that this is a very good starting point for the Japanese people to think about the civil society here in Japan. Thank you.
Interesting, thank you. Georgina, did you have any quick responses to the questions? Or?
Not really, but just I think that just the wind up comments from me. Especially, I'm trying to see myself in a country where there's with COVID, but I cannot obviously because we are still free from COVID. And Solomon Islands being such a small country, 600,000 population, that's about one village in Japan. So yeah, it's kind of hard for me to put myself in your shoes, especially the bigger countries. But for us in Solomon Islands, I would say that I think people have been questioning about the state of emergencies, whether it's really necessary for us to have the state of emergencies rather than just lifting some of the laws that we have. I think the thing for us now, especially for the government, I think with the lack of resources and capacity which we have in terms of human resources when it comes to laws and things like that, I think we should seek support from other countries, even from the region. Maybe the small Pacific Island states, they should try and support each other when it comes to sharing of our resources, because we're such a small country and there's so much the government wants to do, especially in trying to keep the people safe, but then we lack the resources. So it wouldn't hurt, especially if they can also, seek support or advice from the bigger countries, so that we can be able to stay, and also people can be able to move around freely. So yeah, just on that note, I think that's all I can say. And thank you very much for these discussions. Thank you.
Well, thank you. Ricardo, 2 minutes. If you've got 2 minutes of comments.
Okay, thank you very much. I won't take longer. The overall questions here would be on the long-term effects of this pandemic. Interestingly enough, going back to Ramda's question on the local government part, and this can be a long-term effect also in Timor-Leste, because part of the economic response was channeled by not local government, because it's still construction, but by traditional authorities in order to get to the poorer. And Timor-Leste invested a great deal in this fight, partly from the petroleum fund, but it was channeled by the by the traditional authorities, and this was a very interesting development, and it was a new approach that had not been followed before. The social pressure is something that I think we'll all be dealing with, the individual responsibility that we are also being encouraged to take on. We're using masks, and I think this is inevitable. Other pandemics have also had this effect in Hong Kong, and for instance, I remember when I was living there, the flu in 2000, 2003, it also had this effect, and so I believe this will be more widespread. As for the changes to the political culture, honestly, in the case of Timor-Leste, I think that it has shown that the system has dealt particularly well with this situation, and that is an important and upbeat conclusion, because the system has dealt well, particularly in a time of political turmoil and crisis. All the powers worked together, and on the strengthening of the executive, I believe that for every action there's a reaction, and the courts have started to participate in that, and the representatives will also take part in that response. So I'm not too sure about the new normal being the more active executive, but we'll wait and see. Thank you very much.
Fantastic, thank you. So I'm afraid I'm going to have to draw it to a close, but I just want to take a couple of 1 minute to just try and sum up some of the themes, and I'm sure that there are others, and there are many that we'll return to in the next 3 sessions. So we hope we all can rejoin then. But just thinking through some of the common kind of issues that came up. One is about laws and legality and the choice of mechanisms for managing the pandemic. It's always interesting to see a former Melbourne Forum topic emerge, and we had a whole session, a whole forum on culture and the role of culture, constitutional culture, political culture, social culture, and we can see how that is really you know, a dynamic that we should consider when thinking about emergency powers and constitutions again. And also this role of institutions and checks and balances, both in, you know, deciding whether there's an emergency and managing the emergency, but you also see the impact of what has gone on in the past and what might come in the future in terms of those sort of bigger constitutional, institutional relationships. So that's some brief thoughts, and we can return to any and all of these in the next 3 sessions as well. So please join me in virtually thanking our 5 panelists, but also thank you for joining us and participating in what has been a really, really great discussion. I'm sorry I didn't get to all the questions in the Q&A. We will save them and we will circulate them and hopefully pick them up in the next few sessions. So please do join us for the second panel of the Melbourne Forum. It will be on the topic of lawmaking and accountability in responding to COVID-19, and we'll hear case studies from New Zealand, South Korea, Malaysia, Papua New Guinea and Singapore. So if you've not already done so, please register and join us on Thursday, the 10th of September, 2 p.m. Australian Eastern Time. And do remember that there are papers available on the website that you can read in advance. They're very short, but they're full of information. They're really wonderful. So finally, we'd love to hear your feedback about this session so we can make the next 3 even better. And we invite you to complete the short evaluation that will kind of pop up on Zoom as you exit. We really do appreciate any feedback that you've got. So thank you all again, and we hope to see you next week.